giving their insight as well. We have Brian Korn, partner at Manatt, Phillips and Phelps, and we have Yitzy Hammer, co-founder at DLT Law, Richard Levin, who is the partner at Nelson's Mullins Riley, and Scarborough, and Josh Lawler. So let's have a round of applause for our speakers. Thank you, guys.
Thank you. So we're getting the chairs set up. This is going to be the most interesting legal panel you've ever heard. There are things I just learned outside that I didn't even know. So we're gonna really dive into a lot of these issues, and we're going to talk more about just the topic, which is this token a security? Although that's a question that we constantly get and constantly have to answer, and all the issues that stem from there. My name is Brian Korn. I'm a partner at Manatt Phelps in our New York office. Our fintech strategies focuses on online lending as well as buy now, pay later and payments, and in blockchain DeFi transactions, NFTs, which integrate with our extensive entertainment and music practice, and tokenization and token minting and how that integrates with venture finance. And I will let our panelists introduce themselves.
Thank you. My name is Yitzy Hammer, co-founder of DLT Law. It's a blockchain legal advisory practice. And we really work with anybody within a nexus to the space. NFT projects, exchanges, blockchain technology companies, investors coming into the space. We're focused exclusively on blockchain and crypto. And we operate across the globe. Most of our clients come from Asia, North America, and Europe, although we're based in Israel. It's great to be here in LA.
Hi, I'm Josh Lawler. I'm a partner at Zuber Lawler. I'm located here in Los Angeles. The firm is also in New York, Chicago, Silicon Valley, Denver, Phoenix, Minneapolis, and the Dominican Republic. We focus on areas of emerging industry and technology, and I lead our distributed ledger technology practice. We represent constituents from pretty much the entire ecosystem, whether that is a fungible token project, a non-fungible token project, an exchange, a algorithmic trader, another ancillary technology provider, or whatever else it might be. We spend a lot of time trying to figure out how to get various business models to work, whether that's in the United States or otherwise. So we help our clients actually accomplish what they're trying to do within the bounds of regulatory reason.
All right, I'm Rick Levin. I'm the chair of the FinTech and Regulation Practice at Nelson Mullins. We're about a 1,000-lawyer law firm, and I got into FinTech in 1999, 3 years out of law school, back when stocks were traded on the floor by people yelling at each other, and we thought computerized trading was the future. We literally got thrown out of the New York Stock Exchange for telling them computerized trading was coming. I got into blockchain in 2010. My dad's a computer scientist, and I have to admit, I did not buy any crypto at the time because I thought I didn't want to appear to be a Kool-Aid drinking fanatic when I went and talked to big banks. But I have been representing blockchain companies since 2011, and our clients are very early stage companies that are trying to figure out how to do digital assets, how to operate custodians for digital assets, people that are building trading platforms, and then very sophisticated large organizations that are building things like Bitcoin ETFs. We did one, I can't say which one. They all got rejected, unfortunately, not because of bad lawyering, just they don't want to do it yet. The regulators. And we also work with large media companies and others and custodians that are all trying to figure out how to marry technology of the 21st century with laws that were written back when guys wore leather football helmets. So we're extremely busy with that, but it is a challenge for the industry, and I hope today we'll shed a little bit of light on the issues that you all are facing.
So in many ways, when you think about whether a token is a security, and we can talk about whether that's the right question, it reminds me of the Indiana Jones scene where he's running as fast as he can, or pick any movie like The Mummy, to get out of the pyramid, and all of these monuments and issues that you thought were completely immutable and sacred come crashing down. And I think this industry is really so new that we do have institutions that can fail and fail shockingly. Voyager, Celsius, all the the stable coins. the question, I guess, is, I guess I'll start with you, Rick. What is a security? What is the current legal precedent for what makes something a security? And why is that relevant today?
Well, there's the legal answer and the practical answer. And the practical answer is, if the SEC thinks it's a security and you didn't offer it and sell it as a security, you have a problem. Now, we can get into a coffee house academic exercise discussion claiming that something isn't a security because it has utility or because it's sufficiently decentralized. But at its very core, if you think about it, we tell people, did you publicly offer it? Did you privately offer it? Did you airdrop it? Did you give it away? If you did those things to raise capital, the SEC is probably going to say, guess what? It looks like a security. Now, there's the Howey test, which is the classic Orange Grove ownership interest, where you're getting a return on investment from the efforts of others. But then some of the DeFi yield instruments got into trouble because they didn't realize, oh God, there's this other case called Reeves, which is when is a debt instrument a security? And then, oh my God, there's the issue of, hey, could it also be a collective investment vehicle, something that looks like an investment company under the Investment Company Act? And then the final shoe that's going to drop is whether a stablecoin is a security. And the Presidential Working Group on Stablecoins has said they think stablecoins are either a security under Howey, a security under Reeves, they're an investment company, like a collective investment vehicle, or they may be a security swap or derivative. So it's a tricky issue, and they always say it depends on the facts and circumstances, and unfortunately, you always have to look at those facts as applied to your business to determine whether or not the SEC is going to have issue with what you're doing.
So airdrops, is that a sale? It's free.
Well,
anyone can get it. I'm walking past the convention center, lands in my wallet. Have I bought a security? Have you sold me a security?
I would say no on that one, because it's random whether somebody's walking by. But if you get somebody to sign up for an email listing, the airdrop, I think you may have sold a security.
So people always forget it's not just the sale, it's the offer. Yep. And if the SEC believes, there was a company in the late 1990s called Travelzoo, and there's a body of law called the no sale rule, and they tried to argue, hey, we offered people stock in our company, and all they had to do was tell people about our company. And the SEC said, that's the sale of a security without a registration or an exemption. We're coming after you.
Yeah, but that was also, though, a share of stock, which is part of the definition of securities, not an investment contract. So the whole analysis of whether there is an investment doesn't actually play into that, or at least shouldn't. But I will say, to your point, it's the wrong question. Because what people don't get is that the Securities Act of 1933 does not actually regulate securities. It regulates transactions. And the things in those transactions we call securities, and for 80 or 90 years it did not make any difference whatsoever, but now it sort of does. And that's led to a lot of confusion.
Okay, Yitzy, I know you work a lot with NFTs. Are NFTs securities?
I'll give you the standard lawyer answer. It depends.
Well done.
I mean, I think it depends. I mean, you drew on Howey and sort of like made fun of Howey in a sense. But I think it depends on how you're offering it, what you're offering. I mean, the sticky points are usually, what is the expectation? When I'm looking at whatever it is that I'm possibly going to get, is it how?
I mean, the first thing you need to do is you need to divorce the technology from what it represents. I mean, an NFT is a snippet of software code that spits off output from a smart contract located on a blockchain. It's basically a piece of media that effectively records information, which is more or less what paper is. And if you were to ask me how to regulate paper, the first thing I'd say, well, it depends. Is it a share of stock? Is it a paper towel? They get different kinds of regulation. NFTs can represent vastly different assets.
Yeah, but if you look at it, even the SEC commissioner, who people call Crypto Mom, arguably the biggest advocate for blockchain and crypto at the SEC commissioner level, Hester Peirce said, if you fractionalize an NFT, it's going to be a security. Okay?
So now, we have this whole table over here, and everyone at this table owns a 10% interest in the NFT. You could take an NFT that's not a security and make it a security.
Yeah, by the way, I think that her comment there is taken out of context, because if you take the the NFT that represents that paper towel I just talked about, fractionalize it all you want. It's little bits of paper towel.
Yeah, but if you look at a certificated bond,
But
okay,
that would be a security.
A certificated bond, let me walk you through it. Let's say it has a 3-year lifespan. And after the bond is completely paid off, the certificate now is nothing. People sell those bonds. Lawyers are tremendous dorks. You have to excuse us. I have friends who have Chinese bonds hanging in their office because they think the artwork is really cool. They're pre-Chinese revolutionary bonds. Those certificates are not a security. They either expired of their duration or they were overthrown by a government that seized control of a country in a revolution, and the bonds no longer serve any purpose. So you can create an instrument that by definition has a finite lifespan and then transitions. Now, that's not saying I agree with Bill Hinman, this BS concept of sufficient decentralization, which he pulled out of thin air, which isn't embedded in the securities laws. But if you had a piece of art that was a security, and after 3 years it lived its lifespan, it could not be a security at that point.
Yeah, no, absolutely. And I mean, in different examples, I mean, I was at NFT NYC, and there is a person there who owns some water parks in the Philippines where family people go for fun, and he had NFTs out that were, you know, vouchers for 50% off. And they would show up, and after somebody used that, they would do a secondary sale, and he'd get a little royalty off of it, and it would go out, and it would create more business. I don't think anybody would argue that that's a security. It's definitely an NFT, though.
So the issue would also be whether the NFT is a standalone value representation or whether it represents an interest in a common enterprise. If you think about stock, I don't care which share of Apple or Ford or whatever company I have because they're all the same. I do care which NFT I have. One of them could be extremely valuable, one of them could be worthless. We work with sports leagues who want to do NFT projects, and they say we were going to give out the first 10,000 fans are going to get this NFT. Is that something we need to be concerned about? Well, probably not, because most people won't download it, and there's a use case in the ticket, so no one's really buying the ticket for the NFT anyway. But what if you bought an NFT and you liked the look of the NFT, but the NFT also increased in value because it's a depiction of Aaron Judge hitting a home run? I don't know if you know who Aaron Judge is in California, but any baseball player whose stature gains in value, or football or soccer, does that make it a security? Because you're investing in that player's ability and the future value.
Yitzy should probably jump in because of the IP.
And I like that you touched on sports, because I think it's a good example. And again, I'm going back to what are you selling and what are you telling me that I'm going to get? So, for example, I could sell you, I think people look at ticketing as a great way, a great future use of NFTs and blockchain. Currently, stadiums or teams sell out tickets to a game, and then there's scalper prices. So the teams don't see any of the money from the scalper prices. So a great use of blockchain technology and NFTs is to say, okay, let's sell these tickets as NFTs, and then we'll take a royalty from secondary sales. So if I come and I sell you a ticket to the Super Bowl, and I say, here, buy this ticket for $1,000, you'll be able to sell it for $10,000 tomorrow on secondary markets, then I may have sold you a security because there's some kind of like guarantee of future profit here. But if I sold it to you for $1,000, and then the market determined that tomorrow it's going to be worth $10,000, and I said, great, like, look, I'm so lucky. So then I would argue that that wasn't a security. It certainly wasn't marketed as, you know, expectation of future profit. So I really think it depends on how you structure things, and there's also a distinction, I think, between pre and post offering. So in the offering stage, something could be structured as a, you know, unregistered securities offering, but once it, you know, it may have been offered as a security, and then afterwards certain steps could be taken to, if I want to buy it on the secondary market, I may or may not have engaged in
taking with a view to distribute.
Yes.
So tickets are actually really interesting because I could be buying a ticket for personal consumption, but if I buy 1,000 tickets to the Super Bowl, and I clearly want to sell them, and I'm relying on the efforts of 2 or 3 teams to do well, and then the Super Bowl becomes more valuable because certain players, certain teams are in it, or it's close to where the teams play, that could make it more valuable. What's the difference between that and buying a security?
Well, the SEC in their framework, and believe it or not, people say the SEC is opaque and doesn't give guidance. They even created a fictitious coin once called a Howie coin, and they told you this is what not to do. And they've created this framework for analyzing digital assets, which is based on the case law, and they talk about active participants. If you create an enterprise, whether it's a corporation or a partnership or an LLC, or you just function as a loose confederation of people working together, and you're out there marketing and promoting and hyping and touting, and you expect a return on investment from your co-promoters, hypers, touters, and business builders, they're going to say that's an enterprise, and they're going to come after you. If you look, we always tell people you don't want to be Steven Seagal, the Zen master. Now you don't want to be Kim Kardashian in certain respects. All of these people got involved as active participants in an offering of an instrument that was deemed a security, and they received compensation that made them look like they were part of the offering. So, and one last thing, if you buy the Mona Lisa and you expect the Mona Lisa to appreciate in value and it's recorded on blockchain, the provenance, that's not a security. But if you tell people, hey, I'm setting up an SPV and I'm going to sell you a 1/1,000,000th interest in the Mona Lisa, and you're going to receive a digital image, a fractional image of the Mona Lisa, her eyeball or her eyebrows, guess what? The SEC may say that looks like a security.
So let's go back to the question and try and tackle some real world examples. Take us back to the early ICO days. What is it people were doing, and why was it wrong?
Okay, so I've thought about this history a lot. I mean,
And then the next thing we're going to get into is what is the current functioning of the enforcement regimes that enforce these policies, and do we think that that's an efficient way to regulate the market?
There's a regime?
Wait, can I just add one note on a previous subject before we move forward? And maybe I could only I could say this because I'm not a U.S. lawyer, but just because the SEC might say everything is a security doesn't mean you shouldn't do it.
You mean you can comply with the securities laws?
I just mean maybe you need to do it outside of the U.S., keep U.S. citizens outside of the picture. There are ways of doing things and being compliant with other regulatory regimes.
Yes, and we push stuff offshore all the time. To the question, I think what we really had starting out here is the fact that software engineers aren't lawyers, and they figured out that they could raise some money really quickly without going to venture capital and being diluted. So they did. And then you had other people realize that that path worked. So there were profiteers who jumped in, and 2017 happens, and suddenly there's, forgive me, but a shit ton of shit coins that are being offered to everyone. And the SEC has two mandates: preserve orderly markets, protect the Main Street investor. And the Main Street investor was getting absolutely crushed, and nobody knew exactly which administrative body should go in. The CFTC did some stuff, the FTC did some stuff, but the SEC jumped in and pulled the Howey tests to be able to actually go after things. And now they're in a really interesting place because they're stuck with it. And obviously they continue to expand their jurisdiction, but they still have to protect the Main Street investor.
Well, there's a third part of the SEC's mandate, and people don't know this. The original chairman of the SEC was Joseph Kennedy. He was picked by Franklin Roosevelt because Roosevelt said, it takes a crook to catch crooks. And you could see his photo along with a future Supreme Court justice in the lobby of the SEC, Justice Douglas. Now, what they also pointed out at the time the laws were passed was that the industry knew better how to regulate itself than the SEC. Self-regulation is at a core of the American securities laws. So when we look at this, the chairman now likes to point out our job is to protect the investing public. I'm a bit of a smart aleck. I point out, well, Mr. Chairman, actually the law says, 1, promote capital formation, 2, protect market integrity, 3, protect the investors. Now, there's a body of law that says we must presume that the legislature knew what the hell they were doing when they drafted a law, and if they put something in order, you can presume that that's what they meant. So as we look at this, the SEC, they're like an NFL referee. They've got a job to do. They've got to protect people, market integrity, capital formation. I wish they would focus a little more on that, because most people in this room are thinking, Digital assets are a way to promote capital formation in a new and efficient manner. But the SEC doesn't talk about that all too often.
Well, and also they're effectively regulating from Howey and Reeves, which are court cases, not from the statute. The statute is very broad, and if you read it, you'd think almost everything is, a car lease could be a security. Okay, so if you have a token that is likely a security because you're investing in a common enterprise, and the SEC recently has said, look at all these white papers where you have management teams touting the educational acumen of its founders. This person went to Berkeley or MIT or Michigan, and why would anyone care about that in a truly decentralized world? Because you're investing in this token because you think that token will be more valuable than token B. So if you're on the founder side of these tokens and you're not yet decentralized because there's 5 of you in a room, what are your options to comply?
Well, I mean, I jokingly tell people I'm a good half Jewish boy. I like to keep kosher. If you're raising capital, maybe do it as a securities offering in the United States. That's the appropriate way to do it.
Yep.
And then if you want to create an ecosystem token that looks like Bitcoin, we famously tell people there's 5 people that created Bitcoin. One of them, I think, was a lawyer. I'm not going to say who, it wasn't me. But there's a simple elegance to the Bitcoin offering or protocol. They never publicly offered, they never privately offered, they didn't airdrop it or give it away. People earned it for doing work. So if you want to create a token that is not a security, the Bitcoin model is not a bad model to follow. If you want to do an offering in the United States, do it as a security.
Yeah, if you're raising capital in the United States, it's going to be a security. I mean, in terms of fungible tokens, certainly in terms of a lot of NFTs, barring a lot of other use cases jammed in, again, NFTs are just software code, so it can be done. But if you're raising capital, that's pretty much gonna do it. And then
what if you wanted to? So the limitations of U.S. are either Regulation A, which is the $75 million offering, still has to go through SEC review. The private placement, Reg D, accredited investors, 1-year holding period. Well, I don't want a 1-year holding period. I don't want accredited investors. So you've decided to form an offshore entity and offer it offshore. Yitzy, is that a free pass? I know from my days at Citi that we did a lot of global offerings, and virtually every country has its own private placement rule, including Israel and Australia and European Union, prospectus directives. How do you square that as an offshore issuer?
There's never a free pass to anything. And there's no easy answer to anything either. The kind of broad approach that we take is that there's no 1 or 2 or 3 products. Everything needs to be thought of very thoroughly and sort of structured individually for each product, given its product target market. But while you were talking, I just thought of something that I wanted to ask you guys. So basically, the answer, because of the big bad SEC, is either structure yourself outside of the U.S. and don't market to Americans, and that's what most of our clients and many companies operating within the space are doing. They're blocking U.S. IP addresses. Sometimes it's certain states. Sometimes it's all American citizens. But it's also an industry which I'm bullish on, but is also fraught with scams and fraudsters. Maybe the SEC is doing a good job in that they're protecting Americans from a lot of these what would be scams.
Okay, so there's nothing wrong with disclosure. There's nothing wrong with consumer protection. The problem is that we're in a world now where, for I think the first time, something that may be a financial instrument also has other use cases. And being a security comes with a lot of baggage. In terms of secondary trading, in terms of, if you're going to trade a security, you've got to be an exchange or an ATS. Notably, Coinbase and Kraken are not exchanges or ATSs, so they can't trade securities. Well, if you've got a token in the first place, in a lot of cases, the reason it exists, as you're saying, is to pay somebody for doing the work to make the protocol actually function. So if you're going to pay people to do the work to make the protocol function, they've got to be able to transfer that into fiat so that they can pay their taxes, buy their groceries, et cetera. In order for that to happen, there needs to be a third-party liquidity source. You can't just have it being at an issuer level, or else you've got a zero-sum game and things don't work, which is all a long way of saying that if you make these things securities, you're basically tanking in the technology.
Well, I'm going to point out that currently leading cryptocurrency platforms are currently being sued by class action lawyers who are claiming that those platforms are operating without being registered as a broker-dealer or an electronic marketplace, what's called an alternative trading system. And they're violating the securities laws, according to the plaintiff lawyers. I like to point out to people that the plaintiff's lawyers sued Ripple before the SEC sued Ripple. The plaintiff's lawyers oftentimes have an economic interest to get there before the government, or the government doesn't disclose that they're investigating.
So when you say plaintiff lawyers, you're referring to who exactly? Like Salino and Barnes? Or
I was on a panel with David Silver last week.
Well, but it's graduated
Are these people
beyond that.
who are finding a case, or are they people who have responded to an outcry from thousands of people losing more money than they should have invested, frankly, of course, but and building a legitimate argument?
These are not ambulance chasers. We have people who have quit very prestigious law firms. I think Boy Schiller, Quinn Emanuel, and others who have said, guess what? We think there's a whole raft of people that did illegal offerings, and we have 5 years to sue people. We're going to make a lot of money doing it. And then we also have people who did big asbestos, big tobacco, people that have private jets who know how to do litigation financing that are doing this too. So we are preparing to defend a lot of people in class actions that did ICOs. We never did the ICOs. We used to jokingly tell people, if you're going to do an ICO, go raise $3 billion and set aside a third for Rick and the team to defend you. And that's what's happening in some of these cases now. But I will also caution everybody, the Securities Exchange Commission has a very aggressive view of extraterritorial jurisdiction. They once lost at the United States Supreme Court and were told, you can't enforce your laws outside the United States. They went to Congress, and Dodd-Frank, what did Congress do? They said, guess what? You have extraterritorial authority in certain instances. So just because you're setting up in Switzerland or Singapore or the Seychelles or Malta doesn't protect you. If they believe there's a nexus, or Americans have been offered, or American residents have been offered the instrument, they're going to come after you potentially.
Yeah, the latter. I'm not so sure about a nexus. I think you can have an operating company that's not selling that doesn't necessarily get you in trouble, but certainly if you're targeting US purchasers, you're in the crosshairs.
Okay, so you've done the offering, and you get a letter from the SEC that says, we'd like to talk to you about your transaction, and whether it's a Wells submission or it's something worse. We know that the SEC is one of the agencies, also the Department of Justice, the IRS. DOJ, of course, has the exclusive authority to bring criminal charges along with state prosecutors. It's really a panoply of all the states plus these federal agencies. Just give an overview of how they work together, and what do you do when something like that happens?
Well, call him maybe, but I mean, I'll point out that 8 states got together and all went after Nexo on the same day. I think it was last month. Nexo being a platform that handles kind of delegated staking and gives the equivalent of interest. And I can't say, I'm not commenting on whether Nexo is or is not selling securities, but it is interesting that the states all picked one particular day to serve process.
Well, I would take a step back. First off, have a dialogue with the regulators. When you're designing your offering or you're designing your business, now, I don't share the view of certain Silicon Valley law firms, which is they walk their client in by name. To me, that's like putting your head in the mouth of the lion. But you can go have a confidential, no-name discussion through your lawyers with the SEC staff. You can put it into the FinTech Hub and say, we're thinking about doing this. If they vomit all over it, it's probably not a good idea. If they say, we'll entertain a no-action letter, or we think it fits into previous guidance, then at least you can start designing your business. But when they show up and start sending you letters, there are firms that want to fight tooth and nail. And I like to remind people, the United States government defeated the Nazis and the Empire of Japan. You're not going to win.
Yeah.
Okay? Even if you win, you will lose. Arthur Anderson won at the United States Supreme Court eventually, but nobody works for Arthur Andersen. I'm not saying that a certain crypto offering that was conducted that is now fighting a nasty fight is going to lose. I won't name them by name, but I think they're going to lose.
Well, you have two defendants now basically ganging up and filing briefs in the other's case, and it's not even about the case anymore. It's about you're being too aggressive, you're being too mean to us, you don't have the authority to go after us for this reason or that reason. And you know, the SEC, unfortunately, or fortunately, depending on your outlook, has unlimited time, unlimited resources. They're a self-funded agency, so even if the government shuts down, they're one of the agencies that doesn't shut down. It behooves you to be very proactive and act like a practitioner as opposed to. Now, what happens is we all have clients who are very prideful. Somebody told them after they asked 3 other firms that something wasn't a security in 2015, and they're going to ride that dragon all the way down to wherever. And I think that, or you have people who made investment bets and are embarrassed or not looking to admit fault or that this was a bad idea, and didn't take more conservative advice. And so I think that it's really a balancing test over kind of fight or flight. Now, we've seen people who have caved, like I'll bring up the Kardashian case, because they're not interested in this whole debate. They contact Kim's people. She says, here's $1 million. The whole thing's settled by Tuesday. Now, embedded in this settlement is that Ethereum Max was a security, and nobody actually bothered to file a brief or contest that issue, as far as we know. There are lawyers out there who are throwing their their chairs against the wall because here's another skin that they have, saying, well, if we're wrong, why did all these other people settle? Why did BlockFi settle for $100 million without litigating? Why did these other cases go on? These are big questions, and it's the problem with the enforcement. The path of enforcement is that you're going to have people who settle for reasons of their own. They may not fight even though you want them to. You end up with bad outcomes or bad decisions or an inference of a bad decision. And we're left kind of dodging, as mentioned before, the columns of the temple are falling down, and you say, okay, well, I can't do that anymore. Tornado Cash can't do that anymore. So we know what we can't do, but there's really no rule book about what you can do. When are we going to have clarity on what is actually permitted as opposed to trying to read the tea leaves from these decisions?
They don't like to do that. And I'm going to differ. I mean, I've been in the context of contact FinHub and ask, and your call might get returned 3 or 4 months later, maybe. They're not providing no action letters. I've ridden that train with some of the big firms, in case anybody's wondering if it's because we're a littler firm. No, they're not giving no action letters really to much of anyone. I forget which congressperson, but somebody did comment on the fact that BlockFi approached the SEC to ask if they could do what they were doing, which they then later settled for $100 million on. And I think really, when you look at it, the problem is that these cases, Howie, Reeves, et cetera, they don't actually cover the situations the SEC wants to cover. And I'm wildly speculating here, but my sense is they think if they give guidance, you're just going to have smart people like the people on the stage that figure out how to take the guidance and run with it, because we're all really pretty creative.
Well, okay, so there is one elephant in the room we have to talk about. And like all government agencies, the Securities Exchange Commission and the CFTC are subject to what's called the Administrative Procedure Act. People have made the argument, some of us on the stage and others, that the failure to propose rules on how to regulate digital assets violates the Administrative Procedure Act.
So explain that for people, because
So the Administrative Procedure Act says that a regulatory agency, and it's rooted in the Due Process Clause of the United States Constitution, has to propose for public comment a rule. And then the public gets to comment on it, and then the SEC has to digest those and do a cost-benefit analysis, and then adopt rules that are under the laws passed by Congress and the President. And I think everybody on the stage, we would all say, yeah, they need to do that. Some of us asked them to do that 8 years ago. Coinbase has asked them to do that recently. It's an issue that even the senator, one of the senators from Colorado, Senator Hickenlooper, said, and he's a Democrat, please explain to us why you're not complying with the Administrative Procedure Act. So if the industry wants to bang on a drum, rather than debating whether something is or is not a security, the industry could say, we expect the SEC and the CFTC to follow the law that they are subject to, which is to propose rules for public comment and allow smart people in the industry and lawyers to give their commentary on how to regulate the industry.
Now, they did propose a rule that the exchanges that call themselves communication protocols will have to become broker-dealers or expel any tokens that are securities from their platform. And it was buried behind, I think, Treasury.
Yeah, it was a 200-page rule that had nothing to do with digital assets other than that, and that would technically bring every Bloomberg terminal.
So there's your proposal, right? There's your comment period. They probably had death threats, not comments, but again, what is that the future, right? Are these exchanges, are the DEXs? You know, the DEXs are human beings. They're somewhere. They can be pitchforked, and somebody has their address. What happens then? Are they? It's not that hard to form a BD and be a broker, so somebody must really not want to do it if they're going to spend millions of dollars to not be a broker, or an alternative trading system under the alternative test. So what's the future there? Are they going to fight token by token and say this one's not, it stays on Coinbase or whatever, or Gemini, this one is, this one's not, and actually apply the Howey test in a granular fashion? Or are they going to cave at one point and just say, all right, we're broker now, KYC, AML, we're doing full broker suitability, we're doing record keeping, we're recording phone calls, we're having people in a locked room, we're testing them under Series 7, and we're going to have supervisory control.
Yeah, but that doesn't work, though, because the problem is the disclosure requirements. You know, it's not a question of whether somebody gets a broker-dealer license or not. You're right, that's easy. The problem is that, you know, Layer 1 protocol tokens don't operate on profits and losses. Balance sheet is damn near impossible to understand. So, you know, if you can't trade these as a broker-dealer without, you know, Exchange Act reports, or at least a 15C211, which is what you have when somebody's not actually public but still trading, it doesn't work. And again, that kills the technology, that kills the use case.
So what's wrong with disclosure, right? Just disclosure. I mean, everyone's putting out white papers. Put financials out there. Tell us what's happening. Why did the token drop 20% between Saturday and Sunday? You know, these are things no one can explain.
Yeah, no, but it's the wrong disclosures that they're asking. So you're never going to get audited financials here. Now, if somebody wanted
you could get research.
Yes, you could. I was about to say that. If somebody wanted to put out a rule that says, you know, the SRO Foundation that is responsible for this protocol has to put out data on circulating supply and available supply and token inflation, other things that actually matter, possibly spread of the demand for the use case, and maybe Mizari does something similar to that currently. It's just not acknowledged by law, obviously. I'm all for that. I agree. And inform people, no question.
Yeah, but the dirty little secret is that most of the people who did ICOs weren't building a protocol. They just wanted to do an offering, raise a ton of money, and ride off into the sunset.
Yeah.
Okay, let's be candid.
Yeah, so I want to give Yitzy a chance. Tell us what are the main priorities and enforcement issues you're seeing from your clients, and what are the biggest questions you're asked in this topic area?
Elaborate a little bit. What exactly are you asking?
So, for example, is there enforcement outside the U.S. that you're seeing that's trying to be as robust as U.S. enforcement?
I think there's just a lack of clarity. There are new products all the time in the industry. Let's take, for example, DAOs. Okay, how do you structure a DAO? What is a DAO? How do you achieve true decentralization? Who issues the token? What are the requirements to be able to issue the token so that it's, you know, not a security? These are all questions that there's no definitive answer to. And I think it's what makes it fun to be in this industry, but also challenging at the same time. There's no wrong or right answer. There's nobody you can consult with to sort of make sure that you're doing this right. It's very much a learning process.
So you've seen one DAO, right? I've had clients come to me and say, we formed a DAO, It's all in code. Nothing was really written in any language that can be understood. And it's out there.
It's much worse than that. I mean, if it's formed in code, you're already like 10 steps ahead of the game, because half the DAOs are just like a Discord server where you have like a voting mechanism on the bottom, or worse than that. I can't tell you how many DAOs I meet on a day-to-day basis, or how many NFT projects that I've bought into, and they're like, join the DAO. I'm like, where? What's a DAO? Oh yeah, so that multi-layer vagueness on the creator side, on the collector side, on the regulatory side. I don't think anybody knows what a DAO really is, or what it's supposed to look like.
It's a partnership. Come on.
Well, it's a cross between a partnership and a high school club,
well,
where there's really no accountability. If you don't come, nobody cares. The voting thresholds on these are 3 or 4%, right? I mean, that's not even a shareholder vote in a public company.
So, Brian, if we get together, we were talking about this, we were joking before the panel, if the four of us got together and designed a business model to go rip off expensive auto dealers in Los Angeles, and we said we weren't a corporation, we're not an LLC, we're not a partnership, but we did it in a coordinated effort, the guys in the blue and yellow jackets, the FBI, are going to arrest us and say, you were a criminal enterprise. You may not have been a corporation for Delaware public law purposes, but we're going to treat you as
your
an
general
enterprise.
partnership at that point.
Exactly.
So some states have tried to limit liability for DAOs. You can declare yourself a DAO in Tennessee, right? Wyoming, Delaware, and then you have limited liability, but that destroys the overtness disadvantage.
But those aren't classic DAOs, and you're looking at a finite amount of members. I don't know. I think Wyoming's like max 100. Those aren't the DAOs that people are typically trying to set up. I think any DAO with most of these platforms that have like a SaaS-based usage where they're airdropping to users based on their engagement of the platform are looking at tens of thousands or hundreds of thousands of members. None of these structures are appropriate for that. So what is the appropriate structure? I mean, I think one of the most common models that we've seen is like a foundation with a onshore limited liability company providing services to the foundation, and then sort of like the foundation issuing a token, and then moving to some kind of gradual decentralization model. But A, this takes a long time. B, it's very expensive. C, there's that interim period of like the gradual decentralization where you're very likely gonna fall in the security classification, and you don't know who you're in bed with and where you're going to end up being prosecuted and what's going to cost you. So it makes the model, which could be potentially a very interesting one, not financially viable or attractive.
So we're coming to the end of the time. I was going to ask you, Yitzy, about IP protection and best practices on the metaverse, and what your thoughts are there.
I hate the metaverse. And I hate how everybody kind of throws it in together with crypto and blockchain metaverse.
Well, at least we're not calling it the multiverse.
I hate it as an idea, and I hate it as a product. But sorry. But NFTs and IP, there's that's an interesting one. So in many ways, traditional IP laws and licensing fit in perfectly with NFTs, and in many ways it doesn't. I know that under the U.S. Copyright Office, you cannot register copyright unless it was created by a human. And when you're talking about these 10K PFP NFT collections that are generated using some kind of AI, there's typically like 5 or 6 main images and then a whole bunch of accessories that are thrown in and generated, and then out comes this this collection. To what degree was a human involved in creating that? It's a question. Certainly when you're talking about pixelated art, it'd be very hard to argue that it's copyrightable under U.S. law. These are just some of the questions that come up. There's a lot of issues. We only have 1 minute left, so I don't know if it's the time to go into them. We could have started the panel with that, but there's certainly a lot of gray area when it comes to NFTs and IP. But again, I really think that's what makes this such a fun industry to be in, that there's no clear answers, and every day brings new challenges, and what's right today may not be right tomorrow, so just hold on tight and enjoy the ride.
I think one of the most fascinating things about that is we have musicians that do original 30-second pieces they put out on NFTs, and the agent will say to us, you know, there's 10 people who might own a 10-second thread because of the creative process and, you know, who they borrowed from and all this, and sampling, especially EDM, and having that ripple through and actually get embedded into the smart contract so the resale is done correctly and the royalty streams come out is a huge challenge, and almost nobody can really audit that unless they're tracking the transactions and making sure that the payments are done. So I think that is all the time we have. We appreciate you listening. We actually, very few people leave, which is great. And if you want to talk to any of the panelists, we'll be around in the back after.
Thank you.
Thank you.
Thank you.
Amazing, thank you.